You're watching The Business of Law, brought to you by Bloomberg Law and the ABA Journal. I'm Lee Pacquiao. There are several recent opinions in several states around the country that talk about what attorneys can and cannot list on their personal LinkedIn profiles. And quite understandably, this has many practitioners scratching their heads. Joining me now to walk through the issues, we have Adrian Dayton, columnist at the National Law Journal and consultant to law firms. Welcome.
Hey, thanks for having me on, Lee.
Of course. So let's set the table here, starting with the New York opinion. It states that law firms can't describe their services in the specialties section of their LinkedIn profiles, but individual lawyers can. What's going on here?
Well, it's kind of funny. As you can imagine, the legal profession is a little slow to the party. So they came out and said you cannot use the specialties section.
They're generally late adopters when it comes to tech and social media. That's something I've learned on this show.
In this case, they're kind of ridiculously too late because the specialties section doesn't exist anymore in LinkedIn profiles. All right.
So is this just moot?
Well, kind of. The thing is, if you had originally listed specialties, those will now show up in the summary section under, it'll say specialties, but you just need to basically erase the word specialties.
So has any firm gotten in trouble yet over this? Or
no firm has gotten in trouble.
Firms be worried out there?
And none in New York State will, because New York State is not a mandatory state. So the lawyers aren't bound by the opinions of their ethics board.
I see. Yeah. And we also have guidance out of South Carolina and Florida. What's in there?
Yes. So South Carolina has taken the most strict tact, and they've said, look, skills and expertise. Expertise is a derivative of the word expert. You can't say you're an expert. You can't use any word that's anything like expert. And so they kind of just barred skills and expertise completely. So you actually can go into the settings on LinkedIn, remove that from your profile. It takes 2 seconds.
What's the rationale here behind all these three decisions? All of a sudden, it seems like LinkedIn is the target and the sights of ethics regulators in the legal space.
Yeah, you know, it's strange because really, the purpose of legal ethics is to not mislead the public. And I think that maybe some of these ethic boards, they just don't have anything better to do with their time, and they're thinking, let's talk this through. But they're really getting away from the real issue, which is, how can lawyers effectively use these tools to communicate what they do without being misleading?
Yeah, it's tough out there. I mean, say you're a young attorney trying to make a name for yourself. How do you use something like LinkedIn or Twitter without running into the ethics cops?
It's a good question. Well, like with most things, lawyers sometimes get so, tripped up by the details that they miss the point. And the point with LinkedIn is this is a platform where, in a very clear way, you can say, here's what I do, so that when your ideal client reads that, they can immediately say, this is exactly the type of lawyer I need. And so you can do that without, by sharing the types of work you do, by sharing why you're exceptional. It's kind of like my English teacher always said, don't tell me, show me. By showing people through the depth and quality of your experience what you do, not only will you not run afoul of the ethics rules, but you're going to make a much more persuasive argument that you're the right lawyer for the job.
Now, some might point to these stories and say it's indicative of a legal ethics regime that is simply unequipped to deal with today's quickly evolving world. Does this system need an overhaul, in your sense?
Yeah, absolutely. I mean, take a look at Florida. They came out and said judges cannot friend lawyers on Facebook because it shows undue influence. Right? Well, anyone that uses Facebook knows that all it means if you're friends with someone is that they may have met you at one point in your life, right? There's no influence involved there. But it's kind of like, in the old days of, when automobiles were first introduced, the judges didn't know how they worked, and so they didn't make good rules. I mean, I think one of the most absurd example, Cardosa said, if a car is approaching a train track, the car needs to come to a complete stop, and you need to step out of the vehicle and look both ways on the train track before getting back in your vehicle, right? I mean, it's the same thing with social media. They're not taking time to understand how the tools work before they kind of shoot from the hip and make regulations.
Yeah, and it seems like it's a very granular approach. Now, to jump back to the Florida example you just unpacked with Facebook, does it carry over to Twitter? Can judges and lawyers follow each other on Twitter, or is that something that they haven't thought of yet? I mean,
but the truth is
that the next stage here?
This level of detail is really absurd. I mean, if you just take the principle and say, look, you can't mislead the public, and if that's the principle, do not mislead the public, then it's very easy to look at these and say, look, just because I'm following someone on Twitter doesn't mean they're my client, doesn't mean I love them or hate them. It just means that electronically I can see what they share on Twitter, right? And so, we really just need some principles. Well, We need to just live by the guiding principles that already exist in each state's rules. We don't need to break this up into the minutia of, what are the specifics of what you can and can't do on every individual platform, because we know the platforms are going to change. I mean, we saw that with LinkedIn in New York already.
Sure.
It's like by the time they made a very specific ruling, everything had changed.
Generally speaking, I know this can be a tough question, who in this space gets it right? I mean, is there a state out there, or is there a regulator out there that, in your view, really gets it?
That's a good question. I mean, if we're going to look at a state that gets it, I mean, I think you see a lot of states that are taking a wait-and-see approach. Like, let's see what happens, because we don't have any evidence that anybody in the public is being injured or damaged because somebody's been endorsed on LinkedIn, right? All these ethics rules exist because of ambulance chasers, protecting public that aren't savvy enough, that aren't knowledgeable. And do you really think any buyers of corporate legal services are being tricked because, your plumber has endorsed you for complex transactions on LinkedIn, right? Yeah. So, I mean, I think the point of the skills and expertise section is, take it out, leave it on, but it's really kind of irrelevant to the whole point, which is let's use these tools to discuss the things we do and the things that we're passionate about in the industry, and then it can be a tool that's a value and not a distraction from our practice.
Wild stuff. Adrian, thanks so much for stopping by.
Thank you. Appreciate having me, Lee.
That's Adrian Dayton, consultant to law firms and columnist at the National Law Journal. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.